Hello and welcome to Legalese. I'm Ernie Hyde, your host, and this show is brought to you by the Northern Middlesex Bar Association on a monthly basis. And today I have with me Francine Traiger Poor. Francine has been with us in the past, and she is from my office in Shirley, and we are going to cover in a very brief period of time 26 myths that people have with respect to divorce. So let's get going because time is running. The number one myth is that mothers always get custody of their children. Yes or no?
No, not at all. I've had quite a few cases where I was able to get custody to the fathers, but it's when father was a primary caregiver, father was better suited. The courts do look at who's better suited and who's been the primary caregiver of the child.
Okay, and that's changed significantly over the years.
Yeah.
And it's not always the alternating weekend visits for the other spouse anymore either.
Not at all. Every other weekend and one night a week is a starting point. People's schedules vary. Fathers will often get more time if they want it. Schedules are far more flexible now than they used to be.
Right. No-fault divorce is quicker and cheaper.
No, not always. A no-fault divorce simply means that there's no cause for it. No fault means that it's irreconcilable differences, irretrievable breakdown, that you're not citing a cause, and they can be just as nasty as a cause divorce.
Okay. Marital assets are always split 50-50.
Again, 50-50 is a starting point. The court looks at 28 different things before they decide how to divide the marital assets. Earning ability of each party's contribution to the marital assets, a lot of things come into play.
Okay. A spouse will be punished if that spouse happened to have an affair during the marriage.
Oh, this is a big one. I get this all the time. The courts don't care. The only time an extramarital affair will come into play is if the spouse that was having it spent marital assets on the concubine,
the paramour,
the paramour, whatever you want to call them. If he's buying her diamond bracelets or she's buying him trips to the Bahamas, then yes, that's going to have to come back into the pot before it's divided. But infidelity, the courts don't care.
If you leave the marital home, you're going to lose it.
Not at all. Another big one that I hear all the time. It also doesn't make any difference whose name the marital home is in. Right. If it was bought during the course of the marriage and both people contributed to the home, whether by paying the mortgage or cleaning it and maintaining it, it's marital property and it's going to be divided. The only time that may come into play is if there are children. The person who moves out will have a harder time getting custody. So don't leave the kids behind, but don't worry about leaving the house.
Mm-hmm. Okay, you need to have a vicious lawyer when you go through a divorce.
I recommend against it for a lot of different reasons. Not unless you want to give a lawyer lots of money, which I'm all in favor of.
Yeah.
You want a lawyer who's reasonable, lawyers that work together. Lawyers that have worked together in the past are more likely to reach a reasonable resolution than two lawyers who hate each other because their personal animosity is going to come into your divorce and you're going to wind up paying for it. Exactly. You don't want someone who's going to roll over and play dead. You need a zealous advocate, but you certainly don't want somebody who is going to take a scorched earth approach unless it's truly what you want to pay for.
When you think about doing a divorce, the first thing you should do is stop contributing to your 401k or IRA.
It's any lawyer is going to pick up on that immediately, and I've had people who do it, and I immediately look at pay stubs and I see, hey, wait a second, they were contributing to their IRA, now they're not. It's obvious what they did. What we can do is either stop or divide the IRA as of that date, which means that whatever the person who continued contributing has contributed is now all theirs. You're only hurting yourself. Records go back 3 years, so there's no way.
Right. You should stop working overtime.
This is if overtime. The only time overtime pay is going to come into play is with child support, whether it's your income. What the courts are doing now is that if you've worked overtime all through the marriage and the couple has come to rely on that overtime pay, they're going to count it for your child support. However, if now you're divorced, you have more time on your hands and you've got extra financial obligations, you decide to go out and get a second job, they're not going to go back and retroactively modify your child support because of that.
Okay. Inheritance that you receive or your spouse receives during the marriage belongs to the person who received it.
Again, this is a tough one. It depends on a lot of different circumstances. If that inheritance was commingled with the marital funds, if you used it, if you claimed the interest jointly on your tax return, if you both contributed towards managing it, then it's going to be considered a marital asset and it's going to be divided like anything else. However, if you inherited the money, put it aside into a separate account, paid taxes on it all by yourself, managed it all by yourself, never used any of it to contribute to any portion of the marriage, then it may very well get backed out before the marital assets are divided.
Okay. Does not necessarily mean it's not a marital asset, but may not be divided as such.
A marital asset subject to division, right.
Okay. Let's see. Divorce is very expensive.
Doesn't have to be. It depends on the people. If you can come to an agreement with your spouse, if you can agree on the important terms, the fastest thing to rack up any divorce is a child custody dispute. That's going to run into thousands and thousands of dollars. If you and your spouse can work together on co-parenting and come up with an agreement on custody and visitation, if possible, that's going to keep the cost down right there. Mm-hmm. Anything else that you and your spouse can agree on, again, if it's possible, is going to keep the cost down. If you and your spouse can't agree on anything, then yeah, the cost is going to go up. It's really up to the people.
Yep, and it really does, to a great degree, depend on the clients involved as opposed to the attorneys, for the most part. I mean, you do
Absolutely.
get that emotion that you talked about earlier.
But you can also run into a situation where there's an unequal balance of power in the marriage, and that's where you have to be careful. If one party is used to being bullied by the other, then I may not recommend that you come to an agreement with your spouse. I'll do the fighting for you.
Right.
But if everything else has been pretty much equal and you can reach an agreement, then you should.
Okay. Well, I'm thinking about a divorce, and I think what I will do before I file the divorce, I will just take my kids and move to a different state and have my attorney file the divorce.
Hey. That's a tough one. If you're still married, then you have the right to pick up and move your children anywhere you want to. However, you need to establish residency before a divorce can be filed. And if you can pick up the kids and move to a different state and live there for a year, which is the normal requirement for residency, then you can file for a divorce there, and I'm guessing you're not going to have any problem if your spouse doesn't care that you and the kids just moved to a separate state for a year. Mm-hmm. If you're going to try to move and then there's going to be problems. It's not a good idea. It's never a good idea to surprise your spouse.
And it's never a good idea to file for a divorce in one state and then move out of that state with the kids.
Well, no, because you're going to have to come back for all the court appearances. Right. And once you're divorced, you can't leave the state anyway.
Right. Okay. Let's see. As long as the children are living with me in the house, regardless of what spouse we're talking about, the other spouse is going to have to pay for the mortgage.
No, not at all. You get child support. If you are living in the marital home with the children, you have two different sources of income from the spouse. One may be child support, and that's a formula. It's a spreadsheet. You can go online, look up Mass Child Support Guidelines, plug in all the numbers, and a number pops out, and that's child support. That's not going to vary. Mm-hmm. Now, if you're paying child support, you're not receiving alimony. So that's the income that you're going to get from your spouse.
Right.
If you want to stay in the marital home, there are things that can be worked out, whereas the husband will pay, again, I'm assuming the wife is living in the marital home with the children, husband will pay the mortgage in lieu of child support. We've seen that, not always a great idea. But he's not going to be ordered to pay child support and the mortgage. Mm-hmm, mm-hmm. You may have time before selling. The marital home is an asset that's going to need to be divided.
Right.
Might be able to work out that wife will live in the marital home and pay all costs associated with until the last child is emancipated.
Correct.
And then it'll be sold and the proceeds divided.
Right.
But no, you're not going to get the other spouse to pay the mortgage and child support.
Okay, how about we'll save money for the divorce and just not live together any longer?
It's been done. It usually makes your future lawyer a lot of money because there's a mess to untangle when you do decide to finally get divorced. If the marriage is over and you've tried counseling and there is no hope of reconciliation, do not delay the divorce. 2 years down the line, you win the lottery. That's now marital property that's subject to division. We've seen cases where 10 years ago the parties separated, saw no reason for divorce. He went on to build a successful business, which she then got a part of. I've seen other cases where it's been 10, 15 years. Now we've got to go back and take a look at what the parties owned at the time they separated, and it's nearly impossible to do that. So you're looking at current day assets.
Right.
So that retirement fund that you've spent the last 10 years building up is now subject to division, because there's no way we can go back and look at what that retirement fund or your house or anything else was worth 10 years ago.
Right.
There has to be a clean demarcation for a division of assets, and the farther away that you get from the time you stopped living as husband and wife, the more expensive and difficult that's going to be.
You also have probate issues further on down the line, perhaps, depending on the age of the parties at the time. But as long as you're still married, the other spouse has rights.
Exactly.
To assets. And if you're not meaning to divide up your assets with your ex-spouse that's really not your ex-spouse, you're just not living with him or her, you haven't taken care of that by ending the marriage. Okay. I have a retirement account. I want to get a divorce. But I understand that the retirement account that I have belongs to me, and he or she can't get any of it.
It's a marital asset. It's subject to division. Unless you can show that there were premarital contributions that you contributed to it before the marriage and can get a statement as to what that account was worth on the date of the marriage, it's possible that may be backed out of it. But any contributions to retirement funds that occurred during the marriage are subject to distribution.
Okay. Do I have to take the money out and get hit with the penalty and the tax and so on and so forth to give her half or him half? How do we do this?
It's an interesting question, because for most couples, that's done with a QDRO, which is a Qualified Domestic Relations Order. That is a federally approved document. It's signed by the judge, which allows the manager of your retirement fund to take one retirement fund and turn it into two. Now you have two retirement accounts, no tax penalties, no distribution penalties. The only time that that's a problem is with same-sex marriage. Because of DOMA, the Defense of Marriage Act, you can't, a same-sex couple cannot divide a retirement account in that way, because the federal government won't allow it.
Okay, my kids are over 18, so I shouldn't have to worry about paying child support.
Maybe. Child support continues until the child is 18 or graduates high school, whichever comes last, unless they are principally dependent on the custodial parent for support, in which case child support can continue to age 21, unless they are attending college full-time, in which case it continues till they're 23 or graduate college, whichever comes first.
Okay. After my divorce, I can go back to court and change anything I don't like about our separation agreement anytime I want to do that.
Probably not. Most separation agreements, there's two different parts of a separation agreement. It can either merge or incorporate. Anything that merges can be modified. In Massachusetts, anything to do with the children must merge. So anything having to do with your children, custody, visitation, child support, yes, you can go back and change that with a material change in circumstances, not just because you feel like it. Something big has to have changed since the time you signed the separation agreement. Most property division in Massachusetts is incorporated, which means it survives as its own contract, cannot be modified.
Okay. My spouse makes more money than I do, so I want and expect I will get alimony.
It's possible if there is enough of a discrepancy in income. The normal rule of thumb is you subtract your income from their income and divide by 3. And that third is your alimony. That is dependent on whether or not you need it. That is dependent on whether or not you're receiving child support, because if you're getting child support, you're not getting alimony anymore. Depends on the length of the marriage, your contributions to the marriage. A lot of different factors go into it. But the first thing we have to look at is a large discrepancy in income. If she earns $50,000 and he earns $40,000, he's not getting alimony. If she earns $200,000 and he earns $40,000 because he stayed home to raise the children, and now the kids are emancipated, then yeah, he's probably getting alimony.
Okay. If my spouse ever violates our separation agreement, I need to go to probate court. It's the only place I can go.
Yes and no. If it is a violation of child support, anything having to do with the children, anything that merged, then yeah, you need to go back to probate court has exclusive jurisdiction. However, if there is a clause that survived as an independent contract, if it was incorporated, you can file a contempt in probate court, which is probably the easiest, cheapest, and fastest way to do it. However, if for some reason you really hate probate court, no, you can file an action in district court or superior court. You're going to have to file a separate complaint. You're going to have to file a filing fee. I can't imagine why anybody would do it, but no, it's a contract. You can bring a breach of contract suit anywhere.
Okay. All my spouse's credit card debt is in his name and therefore his responsibilities.
Again, maybe. Pretty much everything in probate law is maybe. If they racked up the credit card debt having nothing to do with the family, if they decided to go on weekend jaunts to Vegas or buy themselves expensive cars, or as I mentioned before, buy presents for the girlfriend or the boyfriend, then yeah, as a lawyer, I would make the argument that they get to keep that debt. However, if the debt was accumulated buying things for the family, taking the family on vacation, buying things for the marital home, then no, that's a marital debt and that needs to be divided.
My spouse has told me when I asked about a divorce that I will never get a divorce, that he will never give me one.
Can't happen in Massachusetts. If you file for divorce and if one party says the marriage is over, it's over. There's two ways to go about it. Either you both cooperate and it's cheap and it's easy and it's civilized, or the other party can be dragged through the court system and it's going to be a lot more expensive. But no, if one party wants a divorce, they get it.
Because of the new laws that I've heard about in Massachusetts, once I get a divorce, I can never live with anyone after that unless I marry them.
What you're referring to are the new alimony laws, which states that cohabitation for a period of 3 months is grounds for termination of alimony. So that would apply if you're receiving alimony and you don't want to stop receiving alimony, then no, you can't live with somebody else. And if your spouse finds out about it, your alimony will be terminated. If you're not receiving alimony or don't care that your alimony is terminated, then go ahead and shack up or get married.
Okay, after my divorce, I need to change my will to get my spouse's name off of it.
Again, yes or no, yes and no. Any bequests to your spouse are automatically invalidated upon divorce. So if you've left your entire estate to your spouse with no alternate, then yeah, you need to get your will redone because you're going to wind up basically with no will when the time comes. But if you left something to your spouse and then to your children, then no, you're probably fine. But as a general rule, after a divorce is a really good time to have all of your estate planning documents redone because you probably don't want your spouse as your power of attorney or healthcare proxy either at that point.
After my divorce, I need to change the beneficiary names on my retirement account to exclude my spouse.
You are probably not going to be allowed to. If that's not covered in the separation agreement, then you probably can. But for the most part, for your retirement account, if it's divided, then yeah, you want to go ahead and change your beneficiary, maybe change it to your children. But life insurance policies, normally with a divorce, they have to maintain it for a certain period of time. It's really going to depend on your independent separation agreement and your terms. But if your retirement account is now yours and it's been divided, then yes, you should absolutely change the beneficiary.
Okay, good. And actually highly recommended, I think, to make sure you at least review it to see what that is all about, right? If we split the retirement accounts, we will have to pay taxes and penalties. We went through that basically already, but you won't have to, right?
No,
with
not
the
if it's done properly with a QDRO.
Okay. There are other things that are split with QDROs as well, right? Aren't there other?
Pensions, absolutely. Pensions,
Stock
retirement accounts,
accounts,
stock accounts, anything that there's
investment.
going to be a tax penalty if you try to liquidate it can probably be divided with a QDRO with no penalties.
Right.
Should mention a QDRO is a separate document that needs to be specifically drafted, approved by both parties, signed by a judge, and then submitted to the court. So that's its own process.
And it's one of those things that I will say that when people decide they want to do a divorce on their own, it's one of those things that since it's done at the very end of a divorce, because until then you really don't know what you're splitting and who's getting what until the judge says or you agree or whatever. It's one of those documents that just never seems to get done if someone's not on top of it. So for those of you out there who are thinking about doing your own divorce, or you are doing your own divorce, or have done your own divorce, you might want to go back and examine whether you took the proper steps to divide up the assets that you either agreed to or the judge told you were going to, right?
Exactly.
Okay. Anything I get in a divorce is taxable.
No, not if the separation agreement is worded properly. The QDRO, as we explained, would stop any retirement funds from being taxed. Transfer of real estate, if one party is signing the house over to the other, it's very simple wording in a separation agreement, and I don't think that would be taxed anyway as a spouse transfer. No, and interspouse transfers, as far as I know, are not taxed. You're not going to take any tax penalties from it.
Okay. As soon as my lawyer files or I file on my own for a divorce, I'm going to clean out all of my checking accounts and all of my savings accounts.
And you are going to be in violation of a mandatory restraining order. When you file for divorce, what's called a mandatory restraining order on the marital assets go in place. That means that you cannot sell, transfer, or liquidate any accounts except for daily living expenses without the express permission of the other party. Now, if you're the one who's filing, that goes into effect as soon as you file. If you're the one being served, it goes into effect as soon as you serve.
Right.
That means you can't start messing around with life insurance policies or bank accounts or investments without the permission of the other party. If you are thinking about filing for divorce and you're concerned that the other party is going to do that, what I normally recommend is prior to filing for divorce is go into the bank, get a statement of what is in the account, withdraw half of it, get another statement, open up your own account, and that way when the lawyers go back and say, hey, what happened to all the money in this account? And they will, because the records go back 3 years. You can say, I withdrew it prior to filing, here are the records. And that account will be considered already divided as marital assets.
And that's probably a very good move. And a lot of people seem to get that without a lot of guidance.
Yeah,
but,
don't try to hide it. It's going to be found,
it's going
and
to be
it will
found.
be worse.
Right. I have a spouse, and the spouse is very violent, very mean. Do I have to just sit there until I go through the divorce and get him kicked out of the house or get her kicked out of the house?
Not at all. If you are in fear for your safety, a lot of things can be done to protect you. You go in, file for the divorce in person, get an automatic restraining order, not for the money, but for the person. And you can do what's called an ex parte motion to have them removed from the marital home. And that is a motion to the court to order the violent spouse to leave the home without the violent spouse having to be there. In cases like that, you do an ex parte motion to vacate the marital home. You are escorted to your home with a sheriff or a constable or a police officer who serves the motion on your spouse and removes them from the marital home. They will still have a chance to defend themselves in court, but it gets them out of the house at the same time that they're being served with the divorce papers. Other option, of course, is to go down to the district court and get a restraining order against them and then file for divorce while the restraining order is in effect.
Right.
If you are in fear for your safety, please see a lawyer. See somebody before you start moving forward with this, because if you have somebody who's violent, serving them with papers is only going to make the situation worse, and there are ways to protect yourself.
Good advice. We made it through our 26, but now I have a question that I want you to answer for people who might be thinking about doing their own divorce, and that is, tell me the difference between a 1A divorce and a 1B divorce, and what you file in a 1B in terms of paperwork, roughly, and what you file in a 1B.
Okay. First of all, my main advice to anybody who's thinking about doing this themselves is don't. A good lawyer, we offer flat fee divorces for a flat rate. We can get you through the whole divorce. The paperwork will be filed properly, completed properly. You'll have a separation agreement that you can live with. There are so many pitfalls and loopholes in a separation agreement that to try to draft one yourself, you're just going to wind up with heavy attorney fees on the other end when something falls apart that wasn't covered.
Right.
To answer
And
your,
we've seen them.
Oh yeah, absolutely. That and divorce agreements that are drafted by mediators with no legal experience, because everything is very nice until something goes wrong, and then you have to come back to a lawyer and back to court. But to answer your original question, a 1A divorce, Mass General Laws, Chapter 208, Section 1A, is an uncontested divorce. With an uncontested divorce, you bring all of the terms of your divorce to your lawyer. You say, this is what we want to do with the house, this is what we want to do with the kids. They may be able to give you some advice. This is the flat fee divorce that I was referring to. A lawyer will put that all into legal format and fill out the affidavits of irretrievable breakdown and the joint petitions for divorce and all of the other forms the court requires, and mail it into the court. About a month later, you get a court date, the gavel comes down, and 120 days later, you're divorced. The reason it's 120 days is because the court will issue the judgment 30 days after your court appearance, and it becomes final 120 days. 90
days later.
90 days
Right.
after that,
Right.
the NISI period. So it's a total of 120 days. It's the most civilized, least expensive way to get through any divorce. A 1B is like any other lawsuit.
But before you go any further, on a 1A, you have to be able to talk, discuss, decide,
Absolutely.
negotiate, conclude with the other party
Right.
in order to come up with the separation agreement, as we keep saying. If the two of you can't talk, can't do anything for 2 seconds without yelling at each other and screaming at each other, that's going nowhere. So the 1B is probably the right way to go.
Exactly. Also, the problems with a 1A, again, as we talked about, is an unequal balance of power. If one party is the controlling power in that marriage and they're going to get their own way through sheer force of will, then a 1A without an attorney as your advocate is probably not a good idea.
Yep. Right.
With a 1B, it starts like any other lawsuit. A complaint is filed in the court. A summons is served. It must be served in hand. Don't try to duck service because they'll just publish it and you'll never know what's going on. But it's served in hand and you have 20 days to answer, although the courts really don't care. You can file a counterclaim at that point. We do discovery, which means both parties get all of the information that they need and eventually still try to reach the separation agreement. Even with a 1B, you want to get to that separation agreement. Hopefully convert it to a 1A and walk it into the court. Otherwise, worst case scenario, it goes to trial and the judge decides the terms of your divorce.
And that's a very, very expensive
Yes.
proposition. So avoid that at all costs. But Francine, I want to thank you for coming on today. I want you to tell everyone that comes into the office that I did not force you to be on this program and that I did not threaten you in any way. But I do want to thank you because you're a wealth of knowledge on divorces. And to all of you out there, thank you again for tuning in and watching Legalese. We appreciate your support and continuing viewing. And we will see you again next time.